For a long time, construction didn't have lawyers, as you would imagine. For the longest time, it would be general commercial people in a construction business that would negotiate the contracts. And you do still see that more so in your subcontractors and your smaller businesses. Construction lawyers are fairly new as a concept. I think the issue is that there are huge sums involved in some construction projects, significant risks for businesses. So having a lawyer that understands the risks and how to deal with drafting in particular is very helpful. Construction contracts often go to dispute. The TCC, Technology and Construction Court.
Welcome back, everyone, to this episode of 20-Minute TC. This one's a bit different. I'm very lucky that we have Caitlin, who is a construction associate at Slaughter & May. As I've said to Caitlin before, I kind of know nothing about construction, which is why I think this is going to be really useful. Caitlin, welcome to the podcast. I'd love for you to just briefly introduce yourself.
Of course. So I'm Caitlin, and I am a construction and IEN associate at Slaughter & May. IEN stands for Infrastructure, Energy and Natural Resources. My route into qualification is a little bit different to the other podcasts that you've had so far. So I actually trained in-house at a construction company called ISG. Worked there for 2 years, seconded as part of my training contract into Slaughter & May, and then on qualification joined Slaughter & May's construction team full-time as an associate.
Perfect. And we'll definitely dive into what that experience was like training in-house. I'd love to kind of start with this point of, I don't really know much about construction. And I think that that's what makes this interview interesting, where normally I kind of have a baseline in terms of what to expect. And so maybe if we start right from the beginning, imagine I kind of knew nothing about construction. How would you explain what you do as a construction lawyer?
Of course. Completely honestly, when I joined construction law, I also knew absolutely nothing about the industry. It's not a module that you can take at university. So I think a lot of people are just completely unaware of this area of law. But what's so nice about construction law is that a tangible asset is built at the end of our transactions. So it's exactly what you'd imagine. Every building requires a construction contract. So as you were going to work this morning, I'm sure you walked past a number of construction sites. Each of those sites will have various construction contracts sitting behind it to allow the project to run. And my team work with the various stakeholders to draft those contracts to allow the project to commence, and then give advice throughout the project to allow it to run, hopefully smoothly.
Fantastic. And you said construction contracts. I'd love to know a bit more about what the documents are like behind a typical construction deal.
Of course. So there are a number of documents throughout the process. We typically get involved at the very beginning of projects when they are still working up the design. So at that point, the contracts that we'll be drafting are essentially service contracts. We would call them professional services appointments. So these are the appointments that you would use to appoint architects, quantity surveyors, and the various consultants that will provide feasibility and design advice. Once that has then been worked up, we will then have either a single or a two-stage project. Single stage will then just move straight into the construction contract, which we have a number of standard forms that we use in the industry. A couple of names are the JCT, FIDIC and NEC, and they're essentially boilerplate contracts that are then amended based on the needs of the specific project. And then in a two-stage project, we have, before we move on to the main construction contract, an additional services contract with the contractor, where we will involve the contractor in the process of working up a more detailed design. They may start to procure materials for the project and that sort of thing. So they're the main front-end documents. And then, as with all transactions, there are a number of ancillary documents. There may be parent company guarantees or performance bonds sitting behind the contracts guaranteeing performance. And then we also have documents called collateral warranties, which are a little bit different in that there is a contractual relationship between the employer and the contractor. but there isn't a direct contractual relationship between the contractor and their subcontractors who will then actually be on the site completing the various actions needed to build the building. And to then create a contractual nexus between those two parties, we'll have a collateral warranty that essentially says, in the instance that either we can't claim from the contractor for whatever reason, they may have gone bust, they may have a liability cap that's already been exhausted, it essentially means that in those situations, we can then pursue the supply chain. So these are some of the other documents that also sit within a construction contract, but aren't necessarily sort of the main actual building of the asset.
You said performance bond. I've never heard of that. What is a performance bond?
It's essentially a bank guarantee, or it sort of operates in a similar way to an insurance policy. The bondsmen are typically insurers, and they will guarantee that the contractor will perform the obligations of the contract. And in the event that the obligations of the contract aren't performed, then you can claim on this performance bond. Performance bonds are typically 10% of the contract value. And so if something goes wrong, or in unfortunate scenario where a contractor goes bust, then there may be instances in those situations where you're able to call on a performance bond as part of the re-procurement of the contract.
Got it. And if we, so you mentioned like a few different, I guess, like stages there of what happens, like design. You mentioned, I guess, the actual construction. Are you able to talk through like at what point does a client typically come to you guys, and what what are the stages from there that you typically go through? I imagine it somewhat varies depending on the deal, but how does that typically look like?
Sure. So on a standard project where we're dealing with a completely lay client who isn't able to complete any of these documents in-house, we will be instructed at the very outset of the project. There will be an idea that they want to build something, but there won't actually be any documents of what exactly is going to be built. So we will be involved at that stage to draft those appointments with the architect, quantity surveyor, etc. The quantity surveyor architect will then be involved in the project working up that design. Once those appointments are in place, we will then not be involved in that part of the process. Obviously, we don't have the technical knowledge. And then once the design is sufficiently worked up, employer will come back to us, and then we will work up the suite of construction contracts that will be required to actually build the asset. So we'll draft those. They will then typically go out to tender. The majority of construction projects are competitively tendered. So they may go out to 3 to 5 tenderers. We will get various legal comments back on the drafts that we've put together. At the same time, the technical team and the consultants will receive comments on the design information that they have provided. And then based on a combination of the legal comments and the technical comments, the employer will then choose to pursue a contractor. We will negotiate the contract with that contractor and then sign the construction contracts. And that process can take anywhere from a couple of months to a year, depending on the size of the project. Then once construction contract has been signed, the contractor will have to go and procure their various subcontractors to build the project for them. We aren't directly involved in that process because, like I said, we aren't the party to that contract, or our client isn't the party to that contract. But we typically have an approval right over those contracts. So as they are about to be placed, they'll be issued to us. We'll review the terms in those contracts, confirm that they are aligned with our contract, and then assuming they are approved, contractor will go off and execute them, at which point we get involved again as part of the collateral warranty work stream that I mentioned, of making sure we have that contractual nexus between the employer and the subcontractors. So that's the main part. And then, day-to-day advice, to the extent that there are issues on a project, we may be involved in that, but that's more ad hoc.
But there's some definitions, if you don't mind, I'd love to ask you. So you started with a surveyor. What does a surveyor do?
So quantity surveyor is someone who is involved on the technical side of actually building the asset. So they may tell you how much something should cost, how many bricks are going to be needed to be used for this project, whether certain materials are appropriate, how much they should be costing, that sort of thing. So we have some involvement with quantity surveyors as part of the process, but the main points of contact for us are the client, the project manager, who is typically not the client, but someone within the construction industry that they employ, and then, some limited involvement with the quantity surveyor as well.
And when you said tender, so this is a few companies bidding to carry out the work?
Essentially, yes. So back when I was in-house, we would be the tenderer. And so you would receive an invitation to tender with a suite of construction contracts. Legal team will review the construction contract. That's what I used to do. And then the various people in the construction industry and the teams will then review the technical documents, liaise with their supply chains to see if there's the capacity in the market to complete the project, and generally price and program the project. And so the tender is not only the legal response, but also the technical response on the project you're trying to build.
Got it. And then what's the difference between a contractor and a subcontractor?
Sure. So a contractor, the best way to think of them is they aren't your builder that you're thinking of in your head that is actually building the asset. They're essentially more of a project manager who will have the relationships with the supply chain who are actually the builders and will procure that they complete certain parts of the project. So the main reason that you have a single contractor rather than doing something called construction management, where the employer will directly appoint each of the subcontractors, is one, ease. Then the employer only has to negotiate one contract rather than several. But also it gives you a single point of responsibility. So if there is a failure in the cladding, in a construction management scenario, then you have to pursue the cladding consultant or subcontractor specifically. And if there's also an issue with, I don't know, something else, the M&E, so the mechanical and electrical part of the project, you've also got to pursue that person. Where a contractor means that you only have to pursue one person, and then how the contractor decides to make themselves whole by pursuing their supply chain is their own concern. So that's why we typically have one contractor, and then they then procure it downstream.
Thank you. Yeah, that was very clear. I think it's just whenever I have these talks, I realize how many terms I don't know. So that's very helpful. In terms of when you're, I guess, negotiating these contracts, and you kind of touched on the nature of the legal work, I guess I'm wondering why, from your perspective, does construction need lawyers? Like, what is from your perspective, the role of lawyers specifically in this part of the process?
So it's actually a very good question, because for a long time, construction didn't have lawyers, as you would imagine. For the longest time, it would be general commercial people in a construction business that would negotiate the contracts. And you do still see that in certain businesses, more so in your subcontractors and your smaller businesses. But construction lawyers are fairly new as a concept. I think the issue is that there are huge sums involved in some construction projects, significant risks for businesses. And so having a lawyer that understands the risks and how to deal with the drafting in particular is very helpful. Construction contracts often go to dispute. The TCC, Technology and Construction Court, was designed in part to deal with the sheer number of construction disputes that go through the courts. Having lawyers able to deal with that is very helpful.
And then in terms of the contracts themselves, what are common negotiating points or things that tend to be maybe a bit contentious between both sides?
So the main points of negotiation are essentially the apportionment of risk. So that's primarily in relation to time. If something delays the project, who's going to bear the risk of that time? And cost, if something costs more than originally anticipated, who's going to be bearing that cost? So we have sort of three buckets of risks, you may call them. So we have contractor risks, which is typically a delay in their supply chain or general delay in delivery of materials to site, something like that. That is a contractor's risk. So to the extent that a project is delayed as a result of this, they will have to pay damages to the employer until the project is completed. We then have neutral risks, where it's realistically neither party's fault. And so they are risks such as force majeure, which is like an act of God. And in those scenarios, the contractor won't receive additional cost to complete the project, but they will receive additional time. So it's sort of a split risk. Each party is bearing some of the responsibility. And then we have employer risks. And the main example is employer impediment. If the employer refuses to give the contractor access to the site, or if the employer refuses to approve certain documents, then that's an employer risk. And in that scenario, the contractor will receive additional time and additional money in order to complete the project. So that's the main risk that is discussed in negotiations. And then the other point that is very hotly negotiated in all construction contracts is the risk of physical conditions. So if it's an extension or the fitting out of an already existing building, so redoing the internal part of an office, then it will be whether the services are where you expect them to be. So are the lights in the right place that they were told they would be on the plans, that sort of thing. Or in a ground up sort of building, what is under the ground. So we had a recent example of a project in London where a Roman burial site was found under the site, and it's who's going to be bearing the risk of that. And we typically end up in a position where, save to the extent that a risk was truly unforeseeable to the contractor, because the contractor is the person with the expertise, it's the contractor who then bears the risk of physical conditions.
I guess if you know this, is there a sense that there is like a market standard in terms of what's normal for who bears the risk, or is it somewhat like just depends on the parties and the contracts?
There are definitely standard positions for the majority of risks. Our standard forms of construction contracts that we use in the industry allocate certain risks to certain parties. And so it is typically sort of contractor-led risk sits with contractor, neutral, split risk, employer sits with the employer. So yeah, we definitely do have market positions, but there are definitely instances where clients may have another allocation in mind based on the specific needs of that project.
How international is the work?
It is actually pretty international. As the sort of global council, or we'll be having sort of best friend support from local council to the extent it's needed. So the vast majority of my practice at this stage is domestic, so UK projects. But some of the team work quite a lot on international projects, and I'm actually working on a project at the moment for a hydrogen project over in Africa. It'll be the first end-to-end, fully vertically integrated hydrogen project in the world. So you get then different market positions, as you can imagine. The UK construction market is potentially more developed than some countries, and the apportionment of risk is potentially different. But the large principles of what you need to cover off in a construction contract is the same. It's just where those risks then lie in different jurisdictions.
I have to say, when you say vertically integrated, what does that mean in this context?
So essentially, the project is green hydrogen. You have different colors of hydrogen based on how it's produced. And green hydrogen is then produced by green energies. So solar, ammonia, wind, hydro, electricity. And so it essentially means that this project is going to have all of those elements involved at one location to allow the entire process to occur on the site.
Got it. Did you learn this construction stuff? Was this in your in-house time, or did you study it separately, or like how did you kind of build up your knowledge of the construction side?
I mean, it's been on the job, really. When I joined the industry, I also had no idea about any of the acronyms. There are so many in the industry, and I think it's so easy for other people, and I'm sure I'm guilty of it too, forgetting that an outsider doesn't know what these terms mean and that they're quite industry specific. So it was definitely a case of a lot of research when I joined the industry. I was very lucky that I had a lot of mentors around me that were able to sort of sit me down and give me the sort of construction industry for dummies, like crash course. And yeah, my knowledge is sort of just built up as I've worked in the industry for the past couple of years. So yeah, I think I also wasn't necessarily massively aware of training in-house, especially in my first couple of years of university. It was sort of as I progressed at university and sort of started doing a bit more research that I realized that in-house opportunities also existed. Essentially, training in-house means that you work for a company in their legal team. Obviously, I did so in construction, but the majority of large businesses will have a legal team that will deal with various different aspects of the law. So I joined a construction company, ISG, in their legal function, who at the time, I think there were 12 qualified lawyers, so fairly large for an in-house legal team. And as part of my training contract, I then rotated around the various parts of their construction business. But my training contract, rather than rotating around different areas of law, was a lot more focused on construction law. So I had seats in the different parts of the business, like I said, but my seats in a traditional sense were split up into non-contentious construction, so the transactional side of things, construction disputes and what we do in those scenarios, and then a little bit of work with the general counsel on the sort of wider functioning of the business. Um, and then as part of that training contract, like I mentioned, I seconded into private practice, knew I wanted to see both sides of the coin sort of as I was starting my training, had been very vocal about that. So was able to second into Sorter and May. And then that is obviously very different because I'd gone from working for one client and knowing that client and the stakeholders very, very well to suddenly working for 10, 12 different clients on various projects. And we do occasionally act for contractors, but the vast majority of our work at Slaughter and May is sort of on the employer developer side. So I had to essentially take every argument that I'd learned to run in a negotiation and completely reverse them and argue from the other side, which definitely took a bit of getting used to, but was massively, massively helpful to my training when I then returned in-house. And then I knew on qualification I wanted to be able to act for the variety of clients. So yeah, took the leap into private practice.
And you obviously, so you decided to train at a construction firm within the in-house side. I guess, how did you know that was something you were interested in?
Completely honestly, I didn't. I'd come to the decision that I wanted to train in-house. I knew that in an in-house training contract, you'd get a lot more responsibility at an early stage. You're typically one of either the only trainee or a very small number of trainees in that business. So you get quite a lot of one-to-one training from the people around you, which again sounded great. And the fact that I could sort of make a training contract what I wanted it to be, they're a lot less rigid than your private practice training contracts. And the issue I had is that there just aren't many in-house training contracts that exist. So I'd been looking online and had found a couple that I was applying to. And sort of as I was applying and seeing these different areas of law that I could have worked in, I realized that, fine, I hadn't ever studied construction law, but it actually fitted in quite nicely with the parts of university that I really had enjoyed. So I'd really enjoyed contract law. A lot of that is similar to construction. I'd taken a negotiation module at university, and again, I knew that negotiation was a big part of the job. And then alternative dispute resolution was again something I'd studied at university, and that's a big part of how disputes are typically dealt with in construction. So it seemed like there were a lot of pieces that fit within what I liked. And sort of as I went through the interview process and spoke to people in the business, I realized that it was a pretty good fit. And I've just been very lucky that, yes, I only trained primarily in one area of law, but I like to think that I would have ended up in construction even if I had taken the traditional training contract route.
And I guess now at the Slaughter and May, where does construction sit in terms of the firm's practice areas?
Sure. So we sit within the firm's real estate stream. As you can imagine, real estate and construction go hand in hand quite nicely together. Um, but we also do some wider work with other teams. So we may liaise with the finance team if there's a project finance element in a transaction. And then we also work as a corporate support function. So if public M&A is happening, and for whatever reason, there are assets that have been built that are within the limitation period, we would then be required to review those contracts, check that whether there are any risks, and generally advise on sort of the built environment. So a recent example of that is last year, the firm acted on the merger between Barrett and Redrow. So we were acting for Redrow, who are a house builder. And obviously, given the industry that they work in, significant numbers of construction contracts. So we acted as a corporate support function on that project, reviewing the various underlying contracts and the regulations that sit behind those, and advising on the M&A.
Is there anything I haven't asked you that you think is useful for people to know, whether that's construction, in-house, or anything in between?
I think something that's quite important to know, and that a lot of people don't realize, is the differences between real estate and construction. I think we get it even sometimes with our trainees in the group as they join us, don't necessarily understand the difference between the two. So real estate is a lot more about sort of buying or leasing land, and the ownership of that land. It's a lot more similar to the property law modules that your listeners will have studied at university or as part of the SQA, where construction, on the other hand, is completely different from that. I really don't use the property law knowledge that I gained at university in my day-to-day. And it's a lot more sort of commercial and sort of doing a deal based on the project and the needs of the client. So I think, yeah, the differences between the two areas of law is definitely something that I don't think people necessarily understand or appreciate.
I definitely didn't. Last question then. I guess from my perspective, people may be listening and maybe their firm has a construction seat they could choose, or maybe they're just kind of hearing this for the first time, but maybe it sounds interesting to them. I guess would you have any advice for people who are interested in this space, or anything to share based on your experiences in construction?
I think the main thing is, I mean, the same with most seats. If you do have the opportunity to do a seat in construction, be keen, ask questions. It's an easy industry to do some reading up on, especially given the post-Grenfell implications. There's been huge shifts in the industry. The Building Safety Act was a piece of legislation put in place specifically as a result of Grenfell. So there's lots of reading that can be done around that. And yeah, like I mentioned sort of at the start of the podcast, because of the fact that there's a tangible asset, there's a lot of sort of reading that can be done around the subject. And it's an area of law where you can work in or work alongside multiple different sectors, which is quite nice.
Thank you so much, Caitlin. I feel like I've learned a lot about construction. I also feel like I'm probably just touching the surface at the same time. But yeah, thank you so much for your time, Caitlin.
Thank you.